Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Ferdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Are you Antrium Coleman?
Yes, sir.
Okay. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
This is 17 CF 1004, State of Florida versus Antrium Coleman. You want to admit that you violated probation, correct?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Did you read and sign this admission plea form, which tells you your rights you're waiving?
Sure.
Has anyone forced you or threatened you to enter this admission?
No.
Are you happy with the work your attorney, Ms. Dudley's done for you on your case?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it. Adjudicates you guilty, $100 violation of probation fee, reinstate probation to complete original requirements. The next 12 months on community control sanctions. So is he on regular probation with community control sanctions? Is that what?
Yes, sir, because he has an extended period of probation left.
Pardon?
He has a significant amount of probation left, so the next year will be on community
Oh,
control
I got
sanctions.
you. Okay. All right, well, good luck to you, Mr. Coleman.
Your Honor, one thing the state she wanted to put on the record is that he is required to wear GPS as a part of his probation. He is aware of that, and that he can't be released from the jail until they get the GPS monitor hooked up.
Right. No, you got to have a GPS monitor on you. They'll put it on today, won't they, Mr. Barry?
Probably tomorrow, but we'll get out there as soon as the jail calls us.
Okay. All right.
And I did explain it could be in the morning.
Okay, thank you.
It was previously, the GPS was on Antreon or Mr. Coleman, and it was at $1 a day, and we request that remain.
All right.
Thank you.
Okay, thank you.
Your Honor, that's all I have.
Okay, thanks. Shaw?
Good afternoon, Judge.
Afternoon.
It's Tim Shaw for Thomas Christopher Laggett. It's 12 CF 48C. Judge, we had filed a verified amended emergency motion for early termination of probation and other relief. I understand that the original didn't include exhibits A and B, but I think that was rectified either today or yesterday, which were letters from Dr. Messino and Dr. Risley. Judge, I'll call my client to the stand.
Is this objected to?
Absolutely, Your Honor. The defense is actually asking this court to make an illegal ruling. Under the statute, under 948.04, it states specifically if a defendant is placed on probation for a violation of 794.011, I do have a copy if the court wishes. It says a defendant who is placed on probation or community control for a violation of Chapter 794 or Chapter 827 is subject to the maximum level of supervision provided by the supervising agency, and that supervision shall continue through the full term of court-imposed probation or community control. Your Honor, this court, specifically Judge Flowers, did order a 20-year probationary sentence with 20 years suspended. So for the court to grant Mr. Shaw's request at this time would be illegal under the statute, Your Honor.
Wasn't this something about a surgery or something?
Correct.
Refresh my memory on it real quick.
Judge, if you're asking me to refresh your, or are you going to look back at the motion?
I said I read it, but
yeah,
we had a holiday, and I read it last week, so I remember something about medical issues and surgery or something. Let me look at it. It was wanting to remove his ankle monitor for surgery, I think, right?
Your Your Honor, the ankle monitor was actually removed for the surgery, is my understanding. I believe Mr. Shaw is also requesting the ankle monitor be removed because he's claiming that it will interfere with some type of therapy. If the court wishes to address that separately, then we can do that, but I believe Mr. Shaw was also asking to get off probation, so I thought I would begin with that. But I'll be glad to address the ankle monitor if the court wishes as well, because we believe also removing the ankle monitor would also be an illegal request under 948.30, which requires a defendant on supervision when the victim was under the age of 16, and in this case the victim was definitely a good bit under the age of 16, to be on an ankle monitor. That is not negotiable. It is not. It can be removed for the purposes of, for instance, an MRI or for the surgery itself, but it is required for any supervision that this defendant is on. And that's under the Jessica Lunsford Act.
You got some case law or something, Mr.?
Yeah, I've got some argument, Judge. Ms. Basso indicates that she believes that the court cannot early term probation because of the language in 948.04, which indicates in pertinent part, according to her, and according to the statute itself, that if it's a conviction for 794.011 or any section under 794, that Mr. Laggett would not be eligible. The problem is he wasn't convicted under 794. He was convicted for an attempt. He was originally charged under 794, but he didn't enter a plea under 794. He entered a plea to an attempt, and in the written plea agreement, there's no language as to what statute number it is. So we look easy, and if I could, Judge, 794.011 2A, which is what he was originally charged with, reads, uh, 794.011 2A, the original charge, a person 18 years of age or older who commits sexual battery upon, there's no committing of an offense under that part of the section, under that part of the statute, or in an attempt to commit sexual battery injures the sexual organs of a person less than 12 years of age. You look at the sentencing guidelines score sheet, there's no injury, okay? There's not even an allegation of injury as best I can tell. So it fails on both of those. He was not convicted under either of those. If that's what the state's arguing, I'd say it'd be an illegal sentence because there's no basis for finding that there was a violation of either of those sections. Now, because that requires a completed crime of sexual battery, or if it's an attempt, it requires injury, of which there's neither. What's also important, Judge, is if we look at jury instruction 11.1, and 11.1 is the jury instruction on sexual battery victim less than 12 years of age. And it requires, like I said, the completed act or injury, which neither are found here. But more importantly, he pled to a category 2 lesser, what we call lesser included offense. Not even a category 1, a category 2 lesser included offense. And if the court, and I can approach and show it to the court if you'd like, there's a list of these what's considered lesser included offenses. And they start with, under category 2, category 1's a battery. Category 2, which are permissive lesser included, is sexual battery, and it lists the statute number out to the side as to what the person would be convicted under. Battery is 784.03. It's listed right here. Florida Supreme Court jury instruction. Sexual battery, defendant less than...
Hang on one second. Ms. Basso, he is saying that his client was not convicted under the statute you're relying on.
Your Honor, under the written plea agreement that's on file with the court, he pled to specifically an attempted sexual battery. Sexual battery is under 794.011. That is what he entered the plea agreement to. He is a sexual predator based upon that plea. So yes, He was convicted, is under supervision for a violation of 794.011. That is what he entered the plea to, the attempted. But, Your Honor, that is still supervision for 794. That is what that is what 948.04 says. Anyone who's on supervision for 794 or 827 cannot get off early. That is the easiest way to distill that down. And that is what he entered the agreement into. That was the bargain he entered into. He pled to 794. There is no other statute in play here except the attempt statute that goes with it. But he is a sexual predator. So there's no question that this was a sexual battery offense.
Mr. Shaw, go ahead.
94804, and I'm going to read you the pertinent line. A defendant who is placed on probation or community control for a violation of Chapter 794, and I'm going to leave out the next chapter because it's not applicable, is subject to the maximum level of supervision provided by the supervising agency, and that supervision shall continue through the full term of the court-imposed probation or community control. It says for a violation of Chapter 794. He was convicted of an attempt. The Florida Supreme Court has promulgated these jury instructions, and and Chapter 777 is an attempt. And if I could have read down all these other 794s as lesser included offenses, if he had been put on probation for those, Ms. Basso would be accurate. She'd be correct. The problem is you get down here to some lewd and lascivious. Those are 804s, and that's listed right here in the Florida statutes. That's what he would have pled to. If he'd have pled to an L&L, it'd have been an 804, not a 794, which is what's next is attempt. Florida statute 777.041. It's that's what he pled to. He pled to attempt 777.01. That's what he pled to. Excuse me, 041. Excuse me. And that's the Florida Supreme Court. This isn't, whatever we got written down on a plea agreement or a plea form or anything of that nature. Florida Supreme Court promulgated these jury instructions. And that's what they said an attempt was.
Your Honor, if I may. Your Honor, when a defendant pleads to or is charged with an attempt, it lists both 777 and the actual underlying statute that they're actually being charged with an attempt of. In this case, the underlying statute, that which he is on supervision for, is the sexual battery 794. It's based on that conviction, the attempt of 794, that he is now a sexual predator. That is actually reflected in his score sheet as well. On the score sheet that went to DOC, he's under 794. That's what he's on supervision for.
Well, I was just trying to find the score sheet.
Your Honor, the score sheet is actually in there. It's actually, it was, what is it? It's DIN 918 in the clerk's file there.
Okay, hang on 1 second.
And we also have the written plea agreement in there that actually reflects that as well, that I believe Mr. Shaw prepared.
I did not represent him at that level.
I'm sorry, I thought you were on that case originally.
No. And I don't believe you're going to find anywhere on the the written plea and sentencing agreement the numbers 794.
It's right there, sir.
It may, but it's not on the. I'll tell you, and just because it may be on a score sheet that the state prepares doesn't make it so. The fact remains, the Florida Supreme Court says it's not so. It says it's 777.04.
Your Honor, the judge actually signed the score sheet, making it valid.
It also added 80 points on the score sheet for penetration, and there's an attempt. There's no penetration on an attempt. So that's incorrect as well.
What I want you to do is each of you write me a memo about 5 or 6 pages and lay out your things you want me to look at. And I don't want to snap judge this. I want to, look at what, because now you're throwing statutes at me, and when I looked at this, it was just whether he could have his ankle monitor off for surgery. And y'all are talking about terminating his probation early and that kind of stuff, right? So
we'll be happy to do
We'll take care of that, Judge.
I want to make sure anybody I have before me, I carefully consider what each of y'all's arguments is, and y'all talking about jury instructions and score sheets and all this. It's hard for me to look at, listen to you, try to figure out what some other judge did, 10, 11 years ago, and so y'all give me about 5 or 6 page memorandum with attachments for me to look at in any case law you got. And then we'll set this for, how about October 26th? Is that enough time for you?
Yes, sir.
Mind if I look at my calendar, Judge, make sure, I know I'm going out of town sometime late October, so.
We can do it November 2nd.
Oh, yeah, Judge, I'm out of town, leaving first thing in the morning on October 26th. You said November 2nd?
Yeah, how about that?
That'll work, Judge.
That's fine, Judge.
Okay.
And Your Honor, from probation standpoint, just so the court's well aware, we have removed the monitor from Mr. Laggett numerous times so he could have surgeries, rehab, whatever. The Department of Corrections still stands firm on the fact that we will accommodate Mr. Laggett in removing the monitor while he has to go to the hospital for anything and replacing it back on him as soon as he gets out.
And I certainly appreciate that from probation and parole. The question is, right now, it's not just while he's at the hospital. Dr. Risley has recommended that he have this BLE, which is a sleeve on his legs, for a couple hours a day, which will not work with an ankle monitor. So that's
okay. Well, I try to do the best we can to make the right decision.
Thank you, Judge.
Okay.
And just, I'm sorry, Your Honor, just before everybody leaves, would the court like us to address also the GPS question if the court does not allow the probation? In other words, the second part of Mr. Shaw's question?
Yeah, address it all.
Address it all in there? Okay.
Yeah.
Good. I'll make sure we do.
Thank you, Judge.
Thank you, Judge.
Mr. Sixto Rivera.
Yes, sir.
Your Honor, in Mr. Rivera's case, as the court is aware, Mr. Rivera has chosen to represent himself. And if we end up having a substantive hearing, then I believe that the court may need to inquire again as to conduct basically another Faretta hearing, finding him able to proceed that way. But what we're here for, Your Honor, is the state, after Mr. Rivera announced that he wished to go to trial, as is customary, the state filed a motion in limine, which basically addressed, it's 20 different points of law that there are standard rules and procedures that any defense attorney would be required to follow if they were appearing before this court or any court. And that's really all this lays out, is we just want to be sure that Mr. Rivera understands that these all are applicable to him as a pro se attorney as they would be to any other defense attorney.
And this is 22-12-14 and 22-12-22.
That is correct, Your Honor.
Mr. Rivera, what she has filed is a very standard motion in limine that they file on most defense attorneys, saying, the rules of evidence. We want to make sure you're going to abide by them. If she doesn't do something right and you object, I'll consider it. If you don't do something right, I gotta consider it and either overrule or sustain.
I got a question. So what if that happened already, Your Honor?
Well, this is not your trial, or that already is not your trial.
So
if you want to represent yourself, you got to abide by the rules of
No,
evidence.
I understand that. I understand. So what I'm asking is, again, the fact that this woman caused.
Your Honor, I'm going to object again, because here we go again, saying whatever you want.
She's not on trial, Mr.
So I understand that. I understand she's not on trial, but she is prosecuting me. And while she's prosecuting me, she aided and abetted on a theft of over $10,000 in property, and I have the evidence. So that's what I'm asking.
Honor,
what if that happened already? What if those things that she did wrong happened already? Because when we go to the court, when we go to trial,
Mr. Rivera, that has nothing to do with the charges you are facing.
I understand, but when we go to the trial, my accuser will be here, and I will question that person, and that person will end up blaming her.
We don't know what they're going to say.
Or whatever, but at the end of the day, the evidence will come forward, because I'm going to play by her rules. I'm going to play by the rules of the court. And the evidence will come forward. And once the evidence shows that this woman has been lying and has been aiding and abetting on hurting a 100% disabled veteran, and she knows about it, where does it go? From there, once you see, because you said it at the beginning that you wanted to see that evidence, that everybody says that the state attorney lies. Now, I do have the evidence, and the evidence will be shown because, as I said, I will play by the rules of the court. So once this woman shows that she has lied to the court, and not only lied to the court, but she caused a theft of over $10,000 in property from me while maliciously prosecuting this case, what's going to happen? Because although she's not in trial, I am the one in trial after I was told I was the victim, by the way. This woman caused a theft of my property by lying to the police.
We're not here about whether someone stole your property. We're here about the charges you're facing.
I understand.
And,
But I want that for the record as well.
All right, it's on the record.
That this woman caused a theft of my personal property over $10,000 for maliciously prosecuting me, Your Honor.
She's not prosecuting you. The state of Florida is prosecuting you.
And, Your Honor, this is really part of the basis for the reason I filed this motion is because Mr. Rivera does not understand the rules. And
he's going to understand the rules. He says he's going to play by the rules, and the court's going to make him and you play by the rules.
Well, and that includes relevant evidence, and that's...
Pardon?
That includes the fact that he has to stick to relevant evidence, and these aren't the charges. So
relevant evidence, Your Honor. So I requested to go back to my property because my property, I was kept away from my property due to death.
Sir, we are not here on a property case.
I understand. I understand. What I'm saying is that while I was charged with these false accusations, which shows in the videos for many times, regardless, I was kept from my property, from going from my property. Although the property was abandoned, I requested to go back because the person who accused me, who has done this in the past numerous times, wasn't there. When we come to the court here to request me going back to my property, that way my property wouldn't be abandoned like it was. Ms. Busol stated to the court that she was not aware that the person...
Lower your voice.
No, I understand.
You are lowering your voice. Do you understand me?
Yes, Your Honor. I'm not yelling at you. That she was not aware that the party have left the property, and although it has been 6 weeks...
I told you we're not here for a property case.
I understand
we are not here for a property case.
But her involvement on that caused a theft. Her lies on that day caused a theft of over $10,000.
If you have some complaint, you can deal with it with the sheriff's office.
I did, and they told me, Your Honor, I did, because it was a theft. It was a theft. I called the police.
We are here for your
and
case.
The police told me that they're not able to do anything. That they can steal whatever, they can take whatever they want from me. And I'm not able, and the police are not able to do anything.
We are here for a domestic battery by strangulation.
Yes,
and a battery
we are.
And
I want to make sure now, and I want to state this. My defense is this. And I will make sure that, and I will prove this, because this is the absolute truth. God knows. My defense is that I was falsely accused to be removed from my property in order to steal from me and take my children away from me. Now that happened due to the negligence from the police and the state, and that will be my defense throughout this case.
Are you going to get a jury? Are you going to get a lawyer?
I will not, Your Honor, because I pay already over $10,000 to the gentleman that was here just previous before me. Okay. And instead of him defending me, he placed the Judge Flowers, and Judge Flowers was part of these cases in 2018.
Let me, Mr. Rivera, why don't you have a seat because you're disabled? Have a seat.
Thank you. Oh, I wanted to bring something here. On Sunday, I received notification of a family death, and I'm requesting permission from the court to attend this funeral, as it was a close member of.
Where is it?
It's in Puerto Rico, Your Honor. And the funeral will be Thursday. If I'm granted this permission.
He has, well, are you out on bond?
Oh, I am. Yes.
Your bondsman pretty much has to give you permission for that.
So they told me that I needed to get with you because it's out of although it's a United States territory, it's out of, I guess it's considered overseas. So I'll have to get your permission to attend.
Any objection?
Yes, Your Honor.
I've never in my life been in trouble.
You got a bondsman?
Never in my life been in trouble.
You got a bondsman?
I don't remember who paid. I got the document into my and who was the bailman, but the bondsman.
How much was your bond?
It was $9,000, $9,500, I believe. I've never been in trouble. The only time I've been in trouble.
All right, I got it. I know you haven't been.
Was the person who accused me of this? Hang on a second. They accused me of rape in the past.
I'm trying to consider you, but you keep interrupting me. You have substantial assets here. I'm gonna allow it if your bondsman allows it. Do you hear me, Mr. Rivera?
But then the funeral will happen. Don't worry about it, Your Honor.
I'm gonna allow you to go if your bondsman allows it. Now have a seat. I got to ask you some questions. Have a seat. This is called a Faretta hearing. Do you understand, Mr. Rivera, you have a right to a lawyer. You absolutely have a right to a lawyer. You understand that?
Yes, Your Honor.
And if you can't afford one, the court will appoint a lawyer. And you understand that, correct?
Yes, Your Honor.
And you don't want me to, I tried to appoint a lawyer for you, but you had too many assets, real estate, your income was too high, you appear to be a very successful, intelligent person, and you did not qualify for the public defender, correct?
That's what appears to, Your Honor, but I do not have access to any of those assets as you mentioned, because the person who's accusing me of all this nonsense is my wife. So without being divorced, I cannot do anything. Therefore, all my income, which I have a financial affidavit in the record, for a new one, because I, through another case, parenting, you will see that I don't have any financial way to pay another attorney. And that's what I was trying to explain. The day the public defendant decided that, hey, we don't even need to look into Mr. Rivera's documents because he stated here that he had multiple properties. So.
All right, well, so I don't see an amended financial affidavit in the record.
Not in this case. There is another affidavit due to a family case that I have, and this family case, a financial affidavit was submitted, and this financial affidavit shows that I don't have the funds to get an attorney like you guys are being implying.
Your Honor, apparently, and according to the motion to withdraw that Ms. Rivers filed on behalf of the Public Defender's Office, he has a retirement and disability income of $5,600 per month based on his own testimony of February 9th of 2023. We also have seen documentation that he receives 100% disability from the military, so that is a substantial amount that he does receive. And
That is incorrect, Your Honor. I do not receive 100% disability from the military. I do receive 100% from VA. The military does not pay me 100%.
All right, did you retire from the military?
I medically retired due to my disabilities, Your Honor. I was medically disabled, retiring.
How many years did you do in the military?
14 and a half, Your Honor.
Okay. Well, this disability check, it goes to you, correct?
That's correct.
Not to your wife?
No, that's...
All right, well, it appears at this point that you do, since the check goes to you, you do have funds, sufficient funds to retain an attorney. Well, you have an absolute right to an attorney if you qualify for one, but you have the absolute right to represent yourself. And this is going to be a jury trial now. I can't help you, Mr. Rivera.
I understand.
If I want to help you, I'm not allowed to help you. If I'm up here saying he ought to probably be objecting to that, and you don't, I can't tell you, Mr. Rivera, you need to object, or you need to.
No,
I cannot help you in this case.
I tried to that day to let the court know, hey, the public defender, they didn't even call me. They didn't even ask me for a document. All they did was like, no, we're not going to represent this guy based on what he said in court. And that's what I tried to explain to you guys here, but I was shut down, so I left. And right after that, I had to present the financial affidavit to the other case that I have for the family case. And that affidavit shows it clearly, which if they would have done the job, they would have known it. But I'm sure that she didn't want to do the job because she just came from her office and she's not going to want to show the evidence against this woman.
It's the public defender that says that you made too much money.
But they didn't corroborate that. They didn't check on the documents. They didn't see everything that I have to pay to see if I actually have any leftovers or am I in deficit. And in fact, the assets are essentially frozen because the person who's accusing me of this, I'm married to her, and without that divorce, I cannot access anything. So essentially, I don't have a single cent. And you guys will see it.
Asking, so you want representation?
I would love that, but they didn't even do the job. So, and the people who I hired initially, who I pay out of pocket, decided that it wasn't in their best interest to show the evidence against the state, showing that the state had lied to the court.
Well, I'm trying to talk about whether or not you qualify for legal assistance, public assistance from the state.
Yes, Your Honor. But I want you to understand that's why I don't want to hire anybody else, because not only do I not have the money, but the money that I had to scrap to get and hire the attorneys ended up not wanting to. They wanted to end up playing political games. No. This woman caused a theft of over $10,000 against me while maliciously prosecuting me. The evidence shows that I was told I was the victim, that the other person was the aggressor.
You have to fill out a financial affidavit for a collateral attorney or for a court-appointed attorney.
They would normally, the public defender's office normally would have them to it. Yes, I believe Ms. Rivers was also relying on his own testimony in court, according to her motion, not anything that she made up. It said according to what he testified to in court. That's what he makes.
Yes, I can say that I make 40 something in VA. I can say that I make 17, I think, on the combat related compensation. I can say that I make this much in the other house, but that doesn't mean that I have the money. That means that money is going somewhere else. The money is attached to something else, to another debt already, because of this case. The woman who accused me of this, who had done this multiple times, not only to me, but to her ex-husband as well. Be aware of that, because I'm bringing everything. Now that you want to play by the rules, know that. The person accused me of raping her.
All right, hang on. We're not trying the case right now. I'm trying to figure out whether you are entitled to a public defender or regional conflict counsel or a court-appointed attorney.
See, this, Your Honor, I'll be honest, I'm the most honest person you'll ever find. And I'll tell you this nonsense could go away if the state is willing to listen and do the right thing. I will give him the whole thing in a platter. I already did. I gave him the whole freaking case, the whole thing, step by step, fact by fact, which I have it in that book bag right there, everything to prove what I have shown. If she was willing to listen and do the right thing, this would have been done, and she would have multiple criminals instead of trying to make me a criminal when I haven't done a single thing but help the person who have been doing this.
I tried to tell you a bunch of times, we're not trying your case right now. I'm trying to figure out whether or not you qualify for an attorney.
I understand that, Your Honor. I'm just this. The corruption level is insane. It's too high. It's too much, especially for a color, for a brown guy like me.
So you say you're 100% disabled,
yes, Your
and
Honor.
your VA check.
I believe it's $4,300.
It's not enough to cover. Well, I'm going to order you to fill out another financial affidavit and see if and appoint collateral attorney, regional conflict.
I haven't filled out one, Your Honor.
Regional conflict attorney. Or you must have filled out one with the public defender, didn't you?
No, that's what I was saying here that day. That they didn't even. I called it. So okay, let's back up for a second. You tried to that day. I remember you were like, "We're going. You're 100% disabled, Mr. Rivera. Let's try to get a public defender." I got with the gentleman right here. He gave me the number to the public defender's office, which I called. A secretary, a paralegal, told me, "You have Ms. Rivers appointed to your case. She will check the case and she will give you a call." The next thing I received is a letter and an email stating that they don't want to represent me because I made too much money based on the statement I made here. Never, not once, she called me to sign or see me any paperwork. I never knew who Ms. Rivers was until we stand here for her to object to represent me. Never knew. I haven't signed anything. I haven't done anything with the public defender's office. They didn't even call me. That's what I'm telling you, Your Honor.
Your Honor, if I may, Jay Williams with the Public Defender's Office, he fills out the affidavit with the Clerk's of Court's office. He doesn't fill it out with our office. We simply direct him to the Clerk's office.
All right.
Nothing, no direction, no nothing. I had nothing from the Public Defender's Office.
In court.
Has he got that on file?
I don't see it.
Pardon?
I think you made statements in court that would have made.
All right, I'm going to reappoint the public defender's office and.
Please, or someone else other than Ms. Rivers.
Well,
someone that does their job, because she didn't even do that and she came here to say, I don't want to deal with this guy.
You better stop interrupting me.
Yes, Your Honor.
I can easily revoke that bond and let you sit in jail. I'm
Yes, Your
trying to
Honor.
be patient with you because you're pro se.
Yes, Your Honor.
I'm going to appoint the public defender again and get them to look at, fill out this application here and see if you qualify, because apparently Ms. Rivers did not have some paper to look at. She relied, I guess, she's not here, so I'm not saying she did anything wrong, but I don't know. I'll appoint the public defender and see if you qualify, because I think you need to have representation. I don't want you have every right to represent yourself. I'm not cutting you off from that right. You understand that?
Yes, Your Honor.
You have every right. I think you're intelligent. You know how to handle yourself. But I prefer for you to have an attorney. And you don't have to have an attorney. You understand that? But you seem like you want an attorney, correct?
Like to. That was my first thing. The first thing I did, to hire a private attorney.
I got you. That's why I'm keep considering. I think you want an attorney. And apparently you gave, what, $10,000 to a private attorney and then they got off the case?
I fired them right here because they didn't want to do their job.
All right, well, we're going to try and see if you qualify for a public defender.
We really tried, Your Honor. I'm asking seriously.
Well,
Can we really try this time?
I don't make the, I'm trying every way I can to let you have an attorney. But if you wanted to represent yourself, I want you to understand you have every right.
If it comes to that would be,
Okay.
but yes.
Well, I think it'd be an interesting trial if you represented yourself, but interesting trial if you didn't. But I want you to have an attorney if you want an attorney. I understand that private attorneys are very expensive, and if you gave them all your funds and then they off the case, that I want you to have representation. So I'm going to point the public defender again, because I want to take a good, close look at it and see if you can qualify for public assistance for an attorney, okay?
That's all I'm asking. If someone can actually take a
Now,
look.
let me ask you something. What is going on with your cane and all that kind of,
Your Honor,
what is your, if you don't have to tell me, but you're 100% disabled?
Yes, I'm 100% disabled, and I did submit American Disability Association request for today and any other day that I have to come here into this court, because I was medically retired from the service.
We put you in the most comfortable chair we could.
Thank you. I was medically retired due to spine fusions that I had to have due to accidents in combat. And
all right, that's what I figured. Okay, that's why we made an accommodation for you. Now, I want
correct.
you to understand we are making as best we can.
That is correct.
I'm letting you sit there in the jury while we were having these other individuals, and I'm letting you sit there.
The only question is that I have, and I asked it earlier, I also have the urge to frequently go to the restroom and going through.
We understand that, and you let me know, we'll take the necessary breaks. Okay?
I just cutting through your procedure, and if you're seeing someone else, if there was like one of these chairs and you can park it back here, I can easily not bother anybody.
All right, we'll accommodate you.
I will be
all right, I understand. We'll accommodate you.
Your Honor, I believe the court earlier indicated you were going to allow Mr. Rivera to attend the funeral. Is that correct?
Oh, yeah.
Your Honor, we do have a request. It's standard for this. If the court is going to allow that, we do request that Mr. Rivera be required to comply with the conditions that pretrial services normally needs to have for any kind of travel. He'll need to let them know where he's going, when he's going, any contact, and report in person when he returns. We're asking that he...
All right, you can do that.
Your Honor, so here I have all the information that Ms. Dawson just asked on this motion. So
Okay, give it to pretrial services.
Give it to them. Although it's not signed by any, I don't know who needs to sign it. I haven't filed it yet. I just brought it because yesterday, I tried to file it yesterday, but it was closed. And then today, since I had this, I brought it with
an order
me.
saying he's allowed to travel and comply with pretrial services in case they need an order.
Yeah,
Just a simple.
It won't be till tomorrow, though. I'm sorry. If that's
Yeah, the pre-trial told me that if he was outside of the country, although it's United States territory, you needed to give the permission.
Okay, I'm going to grant the order. Ms. Bassa is going to prepare an order. I'm concerned, though, Mr. Rivera, about your bondsman. He said that person indicated they have no problem with you going out of the country.
I haven't talked to that person since I never talked to that person. I never talked to that, so my family...
All I tell you is I'm giving you permission. Hopefully the bondsman won't cause a ruckus, but you can give the order to the pretrial services and be back. You're going to where? Puerto Rico?
If I'm going, I'm not sure now.
Okay. We'll be back within, 2 days after the service? Is that what you said?
That's what I was looking, because the funeral will be Thursday. I was looking to come back by the weekend.
Okay. Prepare that for me, Ms. Basso, if you wouldn't mind.
We'll do that, Your Honor.
And we will set you for... We'll do pretrial.
Your Honor, it's currently set for 10:30 pretrial.
Yeah, I know, but it's probably going to be continued. I'm trying to save him a trip.
Okay.
I'm going to give you what I'm going to do is give you an extra time. What is our pretrial in November?
Don't think we have one in November. We have trials in November, Your Honor, but I don't believe we have.
We have a December pretrial?
It will be December 27th.
27th?
Yes.
All right, so I'm going to give you, you don't have to come back to court till December 27th, okay? So that should give you time to travel, do what you got to do, get with your public defender. Okay?
Yes, Your Honor.
All right.
Thank you.
Have a good trip.
Mr. Rivera, I handed you an affidavit of financial affidavits.
I couldn't hear what I'll do, since I filed one for the other case as well. Once there, do I have to contact them, or are they gonna contact me this time?
Sir, you need to contact us.
Yeah,
You
contact
I'll contact the office
Make
again,
it on.
and then we'll go from there.
Okay.
Thank you, Your Honor.
All right, Mr. Rivera. Take care, okay?
Thank you.
All right.
Mr. Rivera.
Oh,
thank you
Rivera,
for
you
that.
need to provide the financial affidavit as well, sir.
Well, which is what I handed, just turn it in downstairs.
Once I fill it out, I appreciate it.
Mr. Rivera, I'm sorry I had to raise my voice at you,
You
but
are
you
good,
you were
Your Honor.
raising your voice at me. I had to raise, I understand, but I have to,
You're absolutely right, and I apologize. if
we
you
can't,
get-
that's all right. We
feels like
can't,
that.
we get excited.
Thank
Okay.
you. Have a great day.
Judge, I have a score sheet for Dwayne Seals, who pled earlier today, if I may approach.
Okay.
Please can ask me to provide.
This is Mr. Medina.
Okay. All right.
Yeah. This is Mr. Medina, Judge. He's got two cases.
Oh, Ms. Basso, prepare an order says I granted your motions in limine.
Okay, we'll take care of that, Judge. Thank you.
If you could get that simple order to me today, this afternoon, I'd appreciate it.
I'll see if my ladies can get it ready.
We're going to do this today.
I'm just.
You should be out of jail. You get your signature right there.
That's my, Medina's mine.
Judge, he and I had discussed this last week. I just hadn't heard back from the state. And then she advised me earlier today.
Is this a plea?
It is. It's a plea on a VOP. We had him in this morning, Judge. Sir, you mind if I date this for you?
You have both cases, correct, Mr. Williams?
I do.
Okay, good.
Is it Patrick John Medina?
Yes, sir.
All right, Mr. Medina, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God? Okay.
Basically, Judge, he's going to admit the violation of probation in each case. Probation's recommendation, and what the state and I have worked out, is to convert the remaining term of his supervision to drug offender probation with curfew. Typically that's 7 p.m. to 7 a.m., but modifiable by probation to accommodate his work schedule. He'll also have to enter into controlled substance evaluation within 30 days. They've got on there begin treatment within 60, but I think Mr. Berry usually prefers that be somewhat open-ended because sometimes they can't get them in treatment within 60 days.
That's right, Judge.
All right, Mr. Medina, you want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission? Did you read and sign this plea and sentencing agreement form? Has anyone forced you or threatened you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes.
Court finds admission freely and voluntarily entered. Court accepts it. Now, is it convert remaining supervision to drug offender probation with curfew? And what is this a CS evaluation?
Yes, sir, controlled substances.
Oh, controlled substance evaluation and any treatment?
Yes, sir.
Is that what TX means?
Yes, sir.
Within, is that 3 months?
Within 30 days, and then begin, what
within-
probation really recommended was begin within 60, but Mr. Berry asked that it be left open-ended. Sometimes they
All
can't
right,
actually get
within,
them in.
during your term of probation,
Yes, sir.
about that.
That's fine, Judge.
Is that, did I get it all?
Yes, sir. Are you looking for the $100 cost of prosecution?
Yes, and
All
then
right.
just have to maintain gainful employment.
Huh?
Maintain gainful employment, state asset.
Yeah, maintain employment and cost of prosecution, was it $100?
$100, Judge, and then that'll be a $50 PD application fee for the new application, $100 PD fee.
All right, what are those? Is it adjudicated?
Judge, they withheld. If the state's amenable to continuing to withhold and the court's willing to do that, I'd love to see that. Some judges just won't do it.
Given the nature of the violation, we'll give them one more chance, Judge.
All right, withheld. Don't mess up, otherwise you'll be adjudicated, and that's a convicted felon, okay? All right. Thank you.
Thank you, Judge.
Is there that's it, isn't it?
Yes, sir,
Okay.
I believe so. We handled Ms. Lucky earlier today,
That's right.
Judge.
All right.